Yes.
My Lords, inevitably there's one point I wanted to go back on from this morning, but only one. It's just that I've been reminded that I forgot to show my Lords paragraph 222 of the judgment, which is at core 125, and it's just the finding by the judge that mathematically it's possible to rearrange the equation, that's the J equation, the window-based mechanism, to give a value for VTS minus VTA in terms of J and VTWS. And so what Mr. Buela-Org said in his evidence was that a poll will be triggered when the count of transmitted data units, VTS minus VTA, exceeds and then the rest of the equation. And so the point here is that you have a count which is VTS minus VTA, and this just shows that the window-based mechanism requests the status report based on the value of the count, effectively, if you rearrange the equation.
Yeah, and the judge goes on to issue 4 to say that in his view that doesn't change the points he's made previously.
Yes, that's absolutely right, but obviously in our submission we would say that it's clear in interdigital that there is counting, and that's the VTS minus VTA, and that there is a trigger which depends on the value of that counting, and that's why we would say that it falls within claim 1.
Can I just make sure I'm not misunderstanding the judgment here? Because the quote that the judge gives from the expert has the word count in it. But as I understand it, that's not the point the judge is making. What the point the judge is making is that he's accepting that mathematically it's possible to rearrange the equation
Indeed.
in that way.
Yes.
And in fact, linguistically, you could take the word count out of that and it wouldn't make any difference.
Yes, I don't suggest that he's drawing any particular conclusion in my favour from this, just demonstrating that the equation can obviously be rearranged. And
it can be rearranged so that a poll will be triggered when
yes.
the value, transmitted data units, VTS
yes.
minus VTA exceeds blah, blah, blah.
It's another way of showing that the trigger is dependent on the count in our submission. So, my Lords, I'm moving on to resetting now, and starting with the judge's construction of resetting, which is paragraph 124 of the judgment. And I hope my Lords will appreciate from our skeleton argument that we, in relation to resetting, say that we can win on the judge's construction of resetting, but also in any event the judge's construction was too narrow, and so we win either on the judge's construction of resetting or on a wider construction of resetting. And so, my Lords will see at paragraph 124 that the judge held that resetting means reassigning the count as their previous starting value. In claim 6, this must be 0 as a discrete step, which is distinct from their ordinary changes in value resulting from the counting itself. And if you go on to paragraph 127, he also says at the end of that paragraph, this sounds very similar to Optis's interpretation and does not appear to cut across the proposition that a reset has to provide a fresh start. And so what we say is that taking into account the judge's construction of resetting, if my Lords now turn up paragraph 234 of the judgment, so this is where we're on the particular operation of interdigital in the circumstances set out in paras 230 and 234, we say that this clearly shows...
Page numbers always help.
Oh, sorry, my Lord, I keep forgetting. Core 127.
127.
So at core 127, you've got para 234, and this we say, this we say shows clearly that you've got a distinct step of resetting, and it's a distinct step because it's the result of the receipt of a status report, which you see beneath the 5th row there. And when you get the status report, then you have the distinct step which moves along the sliding window and results in VTS minus VTA returning to 0. And that is then a fresh start for the subsequent counting that happens by the mechanism of VTS minus VTA. And so we say that's reassigning the count as their previous starting value. So that was 0 to start off with, and it's gone back to 0 as a discrete step, which is distinct from their ordinary changes in value resulting from the counting itself. And it's a discrete step distinct from ordinary changes in value because it's the result of the receipt of a status report, and it all goes back to 0. So we say that we can succeed on the judge's construction. However, it's obviously important to look at what the judge had to say about this, which is 248 1 in particular, which is core 131, my lord. VTS minus VTA reflects window occupancy on a continually adjusted and consistently calculated basis. In certain circumstances, it will go abruptly to 0, but it's not a reset as I've construed the term above. It's not a discrete step distinct from the ordinary counting. And then he refers to an analogy, which I'll come back to. We say that that finding that it's not a discrete step distinct from the ordinary counting is wrong because it is a discrete step because of the receipt of the status report. And so we say that it falls within the judge's own construction. Moving on to looking at the construction of resetting afresh, as it were, rather than just adopting the judge's construction. Again, I'm going to do this by reference to the language, the context and the purpose of this aspect of the claim. We say that the language obviously is not a term of art, it's ordinary English, which means to set again or to set differently. And we say that we're at paragraph 124, the judge has put a gloss on the word by introducing the concept of a discrete step distinct from ordinary changes in value, which is not or does not have any justification. And it's worth reading paragraph 126, which is the judge's analogy, the shopping centre analogy. And the judge, sorry, that's at core 110. And the judge's analogy is that it's only a reset when the clicker is started again at the beginning of every day, when the value 0 is put into it. But the clicker is not reset if at some point in the day it so happened that the number going in equaled the number leaving, so the clicker showed 0. We say, well, to start off with, the clicker going back to 0 could be described as a reset even in that situation, but we say that that situation isn't a good analogy because our situation is more analogous to the scenario where the shop asks all the shoppers to leave at once during various points in the day, perhaps at lunchtime or at the end of the day. And so we know that the clicker will be returned to 0 at that point and will provide a fresh start for the counting at that point. So we say that the language and the judge's analogy don't give the restricted or the gloss on the word resetting that the judge set out at paragraph 124. And we also say that the context...
Well, can I just try and understand what your submission is here? Looking at 124, you don't seem to take issue with the words resetting means reassigning the counters their previous starting value.
Yes, I think that's fair to say, yes.
You take issue with as a discrete step which is distinct from the ordinary changes in value resulting from the counting itself. Well, I'm a bit struggling because if you accept reassigning the counters their previous starting value, how can that be otherwise than as a discrete step which is distinct from ordinary changes in value? In what sense is there a resetting, or using the words you accept, reassigning the counters their previous starting value, if this is just ordinary changes in value resulting from counting?
So perhaps I can just try and make my position clear. We say as our primary case, well, we fall within this construction of resetting, because it is a discrete step which is distinct from the ordinary changes in value when it's done as receipt.
So I understand your point.
Yeah.
You say it doesn't matter if the judge's construction is correct. You win anyway on this issue.
Yes.
I've got that. But you're now starting to attack the judge's construction. And what I'm struggling with is, given your acceptance of the first part of his construction, why you jib at the second part.
Well, my lord, I think it's because what the judge seems to be suggesting there is you can't have a reset where it just happens to go back to 0. And so there is some kind of intention behind it.
Take sequence numbers. Suppose you've got a sequence number going up to 4095 because you've got 4096 available. And therefore, given the limitation in the number of bits, you are compelled to go back to 0.
Yes.
After 4095, the next number in sequence is in fact 0.
Yes.
That's not on any use of language a reset, is it?
Well, that's I think the example that possibly the example that, or similar to the example that the judge set out in paragraph 126. But we say.
Do you say that the example I've given to you is a reset?
Well, it starts the counting from the previous value of 0. So we say that could be a reset, but it's not necessary to construe the patent that widely.
I'm baffled now. Is it or is it not a reset? If the next number in sequence is after 4095, because of the cyclical nature of it, is in fact 0, is that a reset or is it not a reset?
I think if it's just the cyclical number, then not.
Right. So where's the judge gone wrong?
Well, the judge has gone wrong because he has said that it has to be distinct from ordinary changes in value, and we say that what happens in a Windows-based system is distinct from an ordinary change in value because you get the receipt of the status report. So maybe it all depends on what the judge meant by distinct from their ordinary changes in value.
Isn't that, I mean, as I understand what the judge is talking about, this is putting words onto it that aren't there. I accept I'm unashamedly doing that. What he's getting at, which I must speak for myself makes sense, is resetting connotes the idea that it's an assignment of a value which is different from the process of just ordinary counting. You're actually resetting. That's why he used the word assigning, because you're assigning the value to the thing rather than letting the process that you have as it normally to do what it does to count, taking its normal operation. There's a distinction between two kinds of operation. That's what I understand him to be talking about. And as I understand your point on you say you win on his construction.
Yes.
The point you're making is that you're characterising the circumstance in which it goes to 0 in that example that you were giving us as being not the normal process of changing value, but as some assignment process. And you could be right about that, or you could be wrong.
Yes, yes.
That's what you're trying to say.
Yes, indeed, indeed.
I'm bound to say I'm not sure I buy it, frankly, but I understand the point you're making, because it feels remarkably like the ordinary process by which that number is being changed. And that's the difficulty you have.
Well, my lord, with respect, it isn't part of the ordinary process. The ordinary process is the counting up. If we look at 2, 3, 4, 0, 1, 2, 3, 4. And so that's the ordinary process before the status report is received. And that's when you go back to 0.
You don't go back to 0 when you get a status report. You go back to whatever the result of whatever's in the status report takes you back to.
Well, my lord, that's if you're
right.
looking at the operation of interdigital generally.
Yes.
And we're concentrating on what is set out in paragraph 234.
Well, I understand.
And we say that's good enough for our purposes.
Well, just a minute. The method takes the number back to whatever, takes the number to whatever the consequence of the contents of the status report is. That's the method. Your case, I understand, is that in certain circumstances, the content of the status report means that the result of the method doing what it normally does puts a 0 in that field, if you call it a field, although it's the result of a sum. But it is nothing other than the consequence of the ordinary operation of the method.
But what it means, and this is the purpose, is that when it goes back to 0 in this case, then you can keep on tracking the resources, and so you're not just counting up to infinity. You need some kind of reset in order to make sure that both the counter mechanism and the window-based mechanism go back so that they don't keep on going to infinity. Otherwise, they wouldn't work, and that's what we say is a reset.
Yes, but it's not. But it's at least what might be said is it's not a reset, because a reset takes you back to a known state. By definition, that's what a reset is doing, is reassigning a value. Whereas in the ordinary operation of the thing, the status report changes the value, but you can't say a priori before you turn your method on and throw it out into the world and get it to work what that value will be, because it'll depend on what's in the status report. That's why it's the ordinary operation of the method and not a reassignment of a value.
Well, it doesn't always, a reset, have to take you back to a known value. For example, if I say I'm going to reset my password, it doesn't mean I'm going to set the same password again. I'm going to set a different password.
Fair enough.
And so in my submission, the ordinary meaning of the word reset is wider.
In the context of this, it's talking about resetting you to a known value, even in your context of your password. It's still a known value. I take your point that you didn't know what it was before you reset it, but the point of it is that you do know what your password is after you've reset it. That is the point.
Well, and you know what this is after it goes back as well. So I'm, my lord.
But you don't, because it'll be whatever there was in the status report.
Yes, but in this scenario that we're looking at, one knows that it goes back to 0.
Right.
And so it starts at 0 and then it goes back to 0 after the status report is received. Mm-hmm. And it's a completely natural meaning of the word reset, or a completely natural description of what is going on here, to say that after the status report is received, then the value of VTS minus VTA is reset, or the window is reset. And so that's why we say that the judge was wrong to put a gloss on it, and that the gloss is not consistent with the natural meaning of the word, or indeed the context, the usual points about the inclusive phrasing, and of course the purpose, which is to keep track of the resources and make sure that you just don't keep going on to infinity. So we say it's a perfectly sensible reading of the word reset, and not one that needed to be read so narrowly by the judge.
So the claim that doesn't say the reset value is 0, why is it a reset?
Sorry, I missed the beginning of that, my lord.
For the claim,
yes.
The point is, I've forgotten if it's 6 or 9, but one of the claims has reset to 0.
Yes, that's 6.
For the claim 1, let's say, you're right, so isn't there a claim which says reset but doesn't say 0?
Yes, that's claim 9, but it's dependent on claims 6 to 8. claim 6 talks about reset to 0.
Right, but there is a claim which resets to a value which doesn't have to be 0.
Yes, yes.
Why does your...
It's 9 dependent on 7.
Okay, thank you. Why does the method you're talking about reset in the case of a claim which doesn't require the value to be 0?
Well, because it
does. The point I'm trying to make in a very complicated way is, I understand the point you're making that the value will be 0 in the context that you're talking about, but I don't understand why it's a reset.
well, because there is a discrete step, the receipt of the status report, that moves the window or the value of VTS minus VTA back to the previous starting point. And the same thing happens if one looks...
How do you know it was a previous starting point?
Well, it empties the window and moves it back to a prior point. I mean, it depends on the particular implement or the particular version of interdigital that we're looking at, whether we're looking at 234 or 248, for example. But the point is that the window-based and counter-based mechanisms need some kind of reset, and the status report provides that and allows that to happen in a window-based mechanism.
You see, what's bothering me is what you seem to be saying. Your argument seems to be driven to be saying that actually every status report effectively resets the window-based system.
No, that's not right, because many of the status reports, the counting keeps on going up. And
it may drop a bit.
Well, my lord, it may drop a bit, possibly in some very extreme circumstances, or some circumstances where there are other polling triggers. Mostly it goes up while the PDUs are being transmitted, and then when a status report is received, it then drops back again, and that's the reset.
But it may not drop back to 0.
No, it may not drop back to 0, but obviously we're, as I say, relying on the situation in paragraph 234, where there is a reset to 0.
What I'm not clear about at the moment is why on your case, a case in which the status report takes the number down from, say, 335 to, say, 300, not 0, but a lower number, isn't a reset on your case?
It is a reset on my case.
Okay.
Yes, it is. Sorry, I probably should have made that clear earlier, because we would have been talking at cross purposes. The reason I'm harping on about 234 is because it goes back to 0, and I need that for claim 6.
Yes. So you say every time a status report is received in the normal case?
Well, no, not... Oh, yes, sorry, yes. Yes, when the status report is received and the number drops back, yes.
And the number drops back to whatever it would be as a result of
yes,
the status report?
exactly.
I see, I'm sorry, I have no doubt it's me.
Sorry, it's probably my fault. It's the after lunch slot when things make less sense.
Something that Mr. Moody Stewart said a moment ago has put a different question into my mind, because I confess I hadn't really paid any attention to the claim dependencies.
Yes.
But can you help me on this, how this works? So I think it's convenient to pick it up from page 107 of the judgment.
In the
Core bundle, page 107.
Yes.
So we've got claim 1 set out in paragraph 101.
Yes.
And then in 102, the judge sets out claim 6.
Yes.
And we see it says method according to any of the previous claims 1 to 5. So that means one of the possible dependencies is directly from claim 1.
Yes.
Further comprising the steps of resetting the first counter 421 to 0 and resetting the second counter 422 to 0. Now, never mind about the identifying numerals, but what are the antecedents in claim 1?
Well, my understanding is you do the whole of claim 1, and then in addition to that, you reset the first counter to 0.
What's the first counter? What's the second counter?
Well, it's your counting.
The point my lord is making is that the feature first counter isn't in claim 1.
Indeed, yes. Yes, and I'm
No,
assuming
no,
the
it's
point my
explaining
Lord
which
wants
it
to
is.
make is to say, sorry, I spoke over my Lord.
No, it's my fault.
I hesitate to put words into my Lord's mouth, but is the point that my Lord is putting is that because it says counter, then it must be talking about a counter when it refers to counting. And my Lord, we take that on the chin because we say, yes, counter, counting, absolutely, that's what happens in a window-based mechanism as well. VTS minus VTA is the counter. It does not say counter-based.
Well, so I think where this goes to is as follows. Number one, it's not immediately obvious how the dependency works because just as a matter of ordinary English, there is no apparent antecedent for either first counter or second counter.
Yes.
However, we're in the world of patents, and the patentee has expressly said that this in claim is dependent on, among others things, claim 1.
Yes.
And there is no trace in the judgment of any argument, or indeed in any of the skeletons, of any argument to the effect of this is an impossible dependency, and the skilled person would understand that it was an impossible dependency. Therefore, it follows that it is not in dispute that the skilled person would proceed on the basis that it is, notwithstanding the linguistic problem, a possible dependency. And that informs their understanding of counting in claim 1. Now, would you take issue with any of the logic that I have outlined thus far?
No, I would accept that it is relevant, although of course the skilled person doesn't necessarily think that the claim 6, it might be a narrowing, if I can put it that way.
Well, of course it's a narrowing.
Yes.
It's a dependent claim.
Yes.
And it is possible to have a dependent claim of identical scope to a superior claim, but it's very unusual. So the presumption is that it's narrower.
Yes.
But
it could also, sorry.
Nevertheless, despite being narrower, it can still inform the skilled person's understanding of claim 1, can it not?
My Lord, I'm certainly not suggesting that it's not an aspect that the skilled person would take into account along with many other aspects. But in my submission, it doesn't introduce the term counter-based, and so it doesn't take the skilled person any further than their general understanding.
Why does it not confirm the skilled person in understanding that when step D of claim 1 refers to counting the number of transmitted data units, that's an operation that involves a counter?
Yes, my Lord, it involves a counter, and there is a counter in the window-based mechanism, VTS minus VTA, because the skilled person who's good at maths and as a bare minimum has primary school maths knows that to get your percentage, you've got to do counting, which means you've got to have a counter.
All right, thank you.
So, my Lord, I think we were basically done on resetting, and I'm going to move on to when now. And that is, as we know, in claim 9. And the question is whether when in claim 9 means immediately upon, or alternatively after which, or in consequence of. And the difference really between the two constructions is whether it has to happen immediately or whether there can be intervening steps. So that's this, whether the step of resetting has to happen immediately. And
I'm
again,
sorry to distract you when you've
Yes.
just started a new topic, but my mind is still going over the previous one.
fair enough.
Can I just ask you a very quick follow-up question?
Yeah.
Which is, when we see reference to first and second counters, does that tie in with step G in claim 1? Because we've got a first predefined value and a second predefined value. So
Well, in my
can one understand that that's how we get a first counter and a second counter?
Well, in my submission, it certainly ties in with the fact that you're counting two things. You're counting transmitted data units and you're counting transmitted data bytes. So it perhaps ties in more with D and E because you know that you've got to count two things. So the first counter
yeah,
is
the
the
breakdown is unhelpful in that regard because, as you point out, the counting is of the number of data units and the data.
Yes, so
and
it'd
the
be
number of data
make more
bytes.
sense if E wasn't a separate step, really.
Yeah. All right. Okay, that's helpful. Thank you.
And the order is always maintained, isn't it? It's always units first, then bytes.
Yes.
So there's a sort of consistency of thinking of the units as first and the bytes as second.
Yes. Yes. So in terms of the meaning of when, we say that as a matter of pure language, when could have either of the two meanings put forward before this court. So it could mean immediately upon, or it could mean after which or in consequence of. By way of illustration of the second meaning of when, which is the meaning that we contend for, I could say, for example, I'm going to go out when the babysitter gets here. But that doesn't necessarily mean immediately. I might give the babysitter a cup of tea or introduce him or her to my children or, put my best clothes on. It doesn't mean that you're going to do something immediately, but in consequence of. So we say as a matter of language, once again, that doesn't give you a clear steer either way. As a matter of context, I took, my lords, briefly, it seems like an age ago, to some paragraphs in the patent, which we can turn up now in the supplemental bundle. Supplemental tab 1, and the paragraphs are at pages 6 and 7. So sub 6 and sub 7, sorry, that's the wrong reference. It's sub 8 and sub 9. 86 and 87, I pointed out that the patentee in these steps, which are the reset step, the reset of the first counter at 86 and 87, uses the words when and if interchangeably. And similarly, in paragraphs 90 and 91, these are all on sub 8, sorry, in relation to resetting the second counter, the terms when and if are used interchangeably in paragraph 91. And so they suggest the fact that the patentee in this description also used the word if, that immediacy is not a requirement. They point towards the reading of in consequence of, which is more closely analogous to if. So we have those points of context in favour of Apple's construction. And in addition to that, we have paragraph 118, which is on sub 10, which is the point we looked at earlier, about the terms comprises and comprising, which makes clear that they don't preclude the presence or addition of one or more other features, integers, steps, operations, etc. And the reason that is important is because if my lord looks at claims 6, 7 and 8, they all start with the word comprising. And so we say that makes crystal clear that there could be intervening steps. And that's another reason why when should be given a wide meaning. There is also a point here about purpose, and we need to turn back to the judgment to look at that, at paragraph 132, which is on page 111. And there's some reasoning here from the judge, which is that it makes more purposive sense, he says, for when to mean immediately upon than for it to mean at any time after or in consequence of. And he says the reason for that is that if there is a time lag, then a superfluous poll could be triggered during it as a result of no further data being transmitted. And it's the object of Claim 9 to avoid that. Now, to understand this paragraph, which we say it isn't quite right, I'm afraid we do need to go back to paragraph 117 of the patent. Sorry, paragraph 17 of the patent.
I may have heard you explain, but when you were reading out 132, I thought I heard you say that it says during it, it's as a result of no further data being transmitted, but it's not what it says.
Sorry, as a result of further data being
further, sorry.
Yes, sorry, my apologies. Did I insert a
No,
not?
you probably didn't. I just my ears.
So if we've got the patent open at the same time at paragraph 17, that's sub 3, you can see that there's an explanation about the fact that superfluous polling due to both sequence number limitation and memory limitation is avoided by the help of one single mechanism. And that's the single mechanism is what we've got at Claim 9, because Claim 9 is going to reset the first counter and the second counter when either the first predefined value is reached or exceeded, or the second predefined value is reached or exceeded. And what this paragraph of the patent explains is that by combining the two criteria, number of data units and number of bytes, into one mechanism, it's avoided that a poll is unnecessarily sent when the first criterion is fulfilled in a situation when such a poll has already recently been triggered due to the other second criterion. And so the point here is that the superfluous polling that the paragraph is talking about is superfluous polling by the other mechanism. So if the bytes have been reached, then both counters are reset, and that prevents triggering by the sequence numbers being reached. And so
I'm sure it's my fault for not understanding, but in the first sentence it says superfluous polling due to both sequence number limitation and memory limitation is avoided. So it's saying you avoid both forms of superfluous polling, doesn't it?
Yes, and I accept that you avoid both forms of superfluous polling. What you don't avoid is superfluous polling by means of other polling mechanisms. So that's the important point.
You mean something completely extraneous to the patent altogether?
Well, there are other types of polls that can be triggered. And so...
but why is the patent concerned with something that's not mentioned?
Sorry, it's not concerned with it, just to be clear. The point I'm trying to make, and I apologise because I'm obviously not making it very well, is that this single mechanism, if you trigger due to one of the, say, sequence number limitation, then you reset both, and so you're not also going to get a trigger from the number of bytes and vice versa. But we say that purpose is achieved by both the counter-based mechanism and the window-based mechanism, and the judge's reasoning at paragraph 132 is flawed because it is talking about preventing superfluous polling more generally. Or at the very least, it's missing the point that you prevent superfluous polling, or you at least reduce superfluous polling by both the window-based mechanism and the counter-based mechanism, because they're both going to reset at the same time. And I also just wanted to mention that, in fact, superfluous polling doesn't have to be eliminated. It only has to be reduced according to paragraph 19.
I don't understand why what you've said is correct. Because if in the single mechanism, which is what we're talking about, because it's claim 9, that's where the when.
Yes, yep.
Isn't the judge exactly right that if you don't effectively immediately reset both, then the other one could be triggered?
Well, but you do reset both in both counter-based and window-based. The point.
The question is, what does it? The question is about what does when mean?
Yes.
And if you, as I understand the argument, you say that the judge decided when means immediately.
Yes.
You say when shouldn't mean immediately; it just means after.
Yes, exactly.
And what's being said against you by the judge is, if it just means after, it means that you could have reached the trigger. So the first counter has reached the trigger, but you don't have to act immediately on your case. So you haven't precluded the possibility of you then reaching the second trigger and triggering the superfluous poll. Well, so the only way you preclude hitting the second trigger is by resetting them both immediately. That's what the judge is saying. That's
well,
right, isn't it?
My lord, 2 points on that. You do, by resetting it when, i.e. after one of them has triggered, because it still has to happen after one of them has triggered, then you do at least reduce the amount of superfluous polling. And that is all that is required by, the fact that you're connecting them, both of them together in claim 9, where the when means immediately, or it means in consequence of, you're going to get a reduction of superfluous polling in both cases. You might get slightly better reduction of superfluous polling if you do it immediately, but you're still going to do it if you do it as a if you do it as a consequence of.
But that's not right, is it? You will rule out the other trigger superfluous poll if you do it immediately.
Yes, but if you do it afterwards, if you do it in consequence of, and
you might reduce it, but the only way you rule it out, which is what the patent's talking about, is by doing it immediately.
Well, that's why I point my lord to paragraph 19,
okay,
which says that the generation of superfluous polls is eliminated or at least reduced.
I see.
So we do say and rely on the fact that if they're connected together, which they are also if when means in consequence of, then you are going to get a reduction in superfluous polling.
Of course, it could be that the superfluous polls that's referring to in 19 don't have to be only the superfluous polls caused by the two mechanisms.
Well, I think 17 is explaining that it's the polling caused
Well, I understand in 17 it is. I get that completely. But you might have thought if you were writing this, I'm going to say this will mean I get no superfluous polls. And a smarty pants would say, well, it means you won't get any superfluous polls of this type. But it doesn't mean you've eliminated all superfluous polling of any sort.
Well, my lord, we say that the explanation about what's meant by superfluous polling is the explanation in 17, which is referring to the superfluous polling is the other type of polling.
I'm sorry to interrupt you. I didn't mean to. But on that reading, paragraph 19 is saying nothing different to paragraph 17, whereas it appears to be saying something different. Now, we've already seen this is a repetitious patent, so at least it's possible that it could be saying the same thing in different words. But it seems a bit odd in this particular context.
Well,
it looks like it's a more general statement.
My lord, in my submission, the explanation of superfluous polling and what's meant by it is the one at 17. And 19 is simply telling you that you get the advantage if you eliminate it or reduce it. And when we come to look at interdigital, Certainly in relation to, as you'll appreciate, we're on the paragraph 234 interdigital method. Then there is obviously, just turning that up again at core 127, there is a reset when a predefined value is reached, and that is the poll. Sorry, there's the poll. We see the value being reached in row 4. Then there's the poll decision and the poll set. The status report is received, and there is no, in this example, there is no possibility of superfluous polling at all compared with a counter-based mechanism. There simply isn't going to be any difference between these two methods in this paragraph 234 example.
Doesn't this highlight why there is something a bit odd about trying to evaluate the characteristics of a method by only looking at its behaviour in one circumstance? If your advantage is to, dare I say it, reduce rather than eliminate, let's not worry about that either, it doesn't matter. Superfluous polling, the only way you can assess whether it achieves that is by looking at its behaviour generally, not by just looking at one example where it actually doesn't make any difference.
Well, the question is whether what's set out in interdigital falls within the scope of the claims, and it doesn't matter whether it doesn't have to fall within the scope of the claims in every way in which it works, because as we've seen from the Hurst case, if the infringing method is only operating for a couple of days a year, that still makes it an infringement. And so the question here is whether or not you have resetting and when, and you avoid superfluous polling in this set of circumstances. And if you do, then you have anticipation.
What I'm struggling with is whether it's really accurate to say that there's an analogy with a case like Hurst, because you're trying to work out whether a method has properties, effectively functional features.
Yes.
And in order to work out whether it does, you have to look at its behaviour in not just one circumstance, but generally, because the reason it's defined in a way which has properties is in order that it behaves in a certain way generally. The fact that you can take one case and say that in this case the behaviour is something doesn't tell you whether the thing has the properties concerned, because you have to look at what it does in other circumstances, because the point of the invention is not simply to do something in one particular set of circumstances, it's to do something in general. So, for example, eliminate superfluous polling. You can't tell whether it's eliminating or reducing superfluous polling by only looking at one case.
But the question you're asking in anticipation is whether it's been done before. And it has been done before in terms of the fact that there is a method.
Well, no, because interdigital isn't describing something that was actually done, it's describing a proposal. But is there not any case law of the boards of appeal on this? I mean, I can't think of any domestic case law, but surely this kind of point must have been considered by the boards of appeal.
My lords, I've checked with those behind me whether that's been looked into, but I'm pretty certain that it has, but I can come back to my lords on that point and confirm that. And as I say, I mean, the other way of looking at it is what is disclosed in interdigital. What does the skilled person understand by what's happening in interdigital? And they understand that it incorporates this method of operation, and this method of operation has all the features of the method. So we say it is appropriate to look at this method of operation.
This isn't a method of operation. This is what happens when a method is applied to a particular set of circumstances.
Well, my lord, you've got to look. It is a method because you have got. I mean, this is demonstrating the operation through the method of a window-based counter using the equation, etc., as per interdigital. And as I say, it's been found not to be unrealistic. It's one of the ways in which it works. And it is a way which, when you look at the claimed features, the features of the method, it falls within the scope of those claimed features. And you need to look, I mean, there's the distinction that the judge draws between method and output, but in my submission, that is not entirely correct, because you do have to look at the output in terms of things like whether it goes back to 0 in order to understand whether it falls within the method of the claims.
I was just looking at how the judge put it in his conclusion on novelty, which is at Court Button on page 132. This is paragraph 248, subparagraph 2. And his summary of his conclusion is, it's not legitimate to look at the behaviour of the method in particular circumstances. One must look at the method itself. And having looked at that way, which very much echoes the way my lord was posing his question, another way of looking at it is the way I was asking about this morning, which is from the perspective of inevitability. So if you can say that the particular circumstances are inevitable, then you might perhaps be able to say, well, therefore, the operation of the method in those circumstances is equally inevitable. But do you not at least have to go so far as to say that the circumstances are inevitable?
Well, we say they are inevitable because they're not an unrealistic way of it operating. So they will occur some of the time.
That's not the same thing at all, is it?
Well, my lord, with respect, it is. Because if you operate this method, it is inevitable that some of the time you will get what is set out at paragraph 234.
But is that right? Let's think about this a little further. So the judge's finding is it's rare. So that implies it depends how long you operate the method for. Let's suppose this happens once a year. So you could operate this method for 364 days, and it wouldn't happen. On the 365th day, it would. Is that enough for lack of novelty?
Well, in my submission, two things. First of all, yes, it would be enough. But the second thing is that example.
But why is it inevitable that you operate the method for a year? Suppose you only operated this method for half a year, and the circumstance didn't occur within that half year.
Yes, my lord, my learned junior is just saying to me it's a proposal for UMTS which is intended to be run for a long period of time. I mean, it's not something that's intended to be run for hours or days, and that the skilled reader knows as part of that as part of their CGK. And moreover, an attempt was made to run the point which my lord is really putting to me, which is this is de minimis and really, really rare. But
de minimis is a different concept. This is inevitability.
Well, the point that the learned judge decided was that it was not entirely unrealistic, and that it would happen, and he set it out as part of the examples of the way in which interdigital would operate. And those examples, I think I pointed you to this paragraph, he said, were part of the skilled person's CGK. So the skilled person reading interdigital would appreciate that in some circumstances it would operate like this. and those are circumstances which could occur in real life, or would occur in real life.
But going back to your answer about entities, you're of course correct that that must be read in its context, and the context is it's a proposal to amend. It's a change request for release 7, but it's a proposal for a change request. So yes, it has the technical content that it has, but why is the skilled person to understand that the change request is going to be accepted and going to be implemented? That's a step further, isn't it?
But in my submission, that wouldn't be necessary in order for us to succeed in anticipation, because the skilled person can still understand everything about its operation from reading the document. And they include this mode of operation at paragraph 234.
Okay, thank you.
My Lord, I'm just checking where I am in my note. And I was about to go, actually, on this very point to paragraph 246. Near about halfway down the paragraph that's on core 131, it says it can be no answer for Apple to try to limit itself to situations where there are no intervening PDUs. That's the one we're talking about at paragraph 234. Both for the reason given above that the method is always the same, and because the transmitter does not know, etc. And we say the learned judge was wrong here in saying that Apple couldn't limit itself to those situations, that in fact that is appropriate and consistent with the law of anticipation as we went through it earlier.
So what is the I'm just trying to understand how the method works. The point about the when is it the case that in the interdigital system, what you call the reset always happens after more PDUs have been sent? Is that the point?
It always happens after the status report has been received. So that's what the judge would call an intervening step. Whereas in the counter system, it happens once the threshold is reached. It reverts back to 0 without before the receipt of the status report.
So what's the you were submitting to us that the judge was wrong to have the word discrete, and
yes.
That was because you have a I'm sorry, does it come to this? You say that the method is being performed in the case when the status report comes back.
Yes.
Before any other PDUs are sent.
Yes.
And the judge decided that that wasn't a reset because...
Well, there were two. He decided that wasn't a reset because he said it wasn't a discrete step. And we say that's wrong because it is a discrete step. It happens after the status report is received. And he also decided that it didn't happen when the first predefined value was exceeded, or whatever the wording is, because it happens if one looks at paragraph 234 after the status report has been received.
I think at the moment I'm not understanding the judgment rather than... So why is what happens not when on the narrow construction?
Well, because he says that, the judge says that there is a short period of time, which is after the poll is set, but before the status report is received, when he says there could be superfluous polling. And it might be easier to understand the reasoning.
Well, he's right about that.
Well, it's not going to be superfluous polling in paragraph 234 due to the other trigger. By the other trigger, I mean either the bytes or the PDUs.
Why not?
Because there's no more increase in PDUs, because the trigger is set before any more PDUs are sent. So it might make more sense if my Lord looks at paragraph 238, which you'll appreciate is not what we rely on, but that compares the window-based with the counter-based in a situation where further PDUs are sent after the poll is transmitted, but before the status report is received.
Mm-hmm.
And so, looking on the right-hand side of that column, which is the counter-based trigger, you can see that the counter-based trigger is reset to 0 after 1, 2, 3, 4, 5 rows, if I can put it like that.
Mm-hmm.
Whereas in the window-based trigger, on the same row, you set the poll, but then you've got another, on this instance, or this method of operation, you've got another PDU transmitted before you get the status report. So that what the judge is saying is you've got a time lag here when another PDU could be transmitted before you get your reset.
And you don't disagree that these are realistic?
No, I don't disagree that these are realistic. But so is paragraph 234.
Can I just ask a different question, which is about your when-if point?
Yes.
And I see what you say about the specification, but we just look at claim 9, which is what this goes to. Method according to the previous claim 6 to 8, wherein the steps of resetting the first counter and the second counter is performed when the first predefined value is reached or exceeded by the first counter, or the second predefined value is reached or exceeded by the second counter. Now, the effect of your submission based on passages of the specification to which you drew our attention is that you could substitute for the word when in those two instances the word if.
Yes.
But suppose we do that.
Yes.
Why is not this claim then coterminous with claim 6?
Well, because claim 6 requires a reset to 0. So this is wider because it's dependent on claims 6, 7 and 8.
Yeah, but that's a point about dependencies, because claim 7, as Mr. Moody Stewart pointed out, isn't dependent on claim 6. But if you leave that aside, if we just focus on the dependency on claim 6, why isn't it coterminous?
Sorry, I have got an answer to this. I think someone will tell me if it's wrong. It's because the point is that you do the resetting when the first predefined value. Well, you reset the first counter and the second counter if or when the first predefined value is reached, or when the second predefined value is reached. So this is why it's the single mechanism, because you reset both of them when or if one of them is reached, whereas that isn't what happens with claim 6.
It's because of the or.
Yes.
Why isn't it what happens in claim 6? Because claim 6 does reset them both at the same time. Because it says and, you reset them both.
Yes, you don't necessarily have to do them at the same time. So you might reset just one of them when the first predefined value is reached, and then you reset the other one when the second predefined value is reached. But is
that really what claim 6 means?
Well, it
doesn't read like it off the top of my head, I must say. It says because these are steps. it's not just saying, and when you reset it, you have to reset it to 0. It's saying the method comprising the steps of resetting the first one to 0 and resetting the second one to 0.
But the point about claim 9 is the resetting of both of them is dependent on only one of the values being reached. Which isn't the case with claim 6. I don't think there's a dispute about this, by the way. I think it might be one of the few things my learned friend and I agree on.
9 is necessary to deal with the superfluous.
Yes,
Oh.
yes. Yes, the point of 9 is that you're going to send both triggers back, or reset both triggers, when only one of the values has been reached.
And it applies in both 6 and 7, whether it's reset to 0 or not.
Well, six doesn't have to set both doesn't have to reset both the counters when only one of the predefined values is reached.
I think what I'm struggling with is if I just lift and drop the words of claim 6 onto the end of claim 1 in a sort of incautious kind of way, which is what you might have thought you should do, you have a method, and you look at start at claim 1, wherein the method comprises the steps of transmitting sequence of counting units and bytes, requesting a status report if the counted number of transmitted units exceeds or predetermined value, or the counted bytes exceed value, resetting the first one to 0, resetting the second one to 0. So you reset them both after you've done the request, which has the OR in it. So I'm not. Is that not a reasonable reading of it?
Well, my lord, it might be that we need to go back to the various embodiments and look at that. But in any event, it would help me.
It's a bit to construe the claim as being restricted to the embodiment.
But it would help me, my lord, I would say, if that were the case, because it means that if and when are being used interchangeably.
Okay. But it didn't involve if and when.
Well, claim 1 says if.
This is the point. I think, at least from my perspective, the point I put to you is the point that my lord put to you, that if claim 9 means if, in the way you say if is to be read in a different sense from when, in other words, not immediately, then it doesn't add anything to claim 6.
Well,
I take your point about there's a specificity about zeros in claim 6, but aside from that, it seems odd that that's the right way of looking at it.
well, my lord, the other issue with what you're putting to me, which I'm dealing with on the hoof, because as I say, this is not something I think that was argued at first instance and hasn't been put forward on appeal by either party, is that claim 9 uses the word or, and as I say, all those involved have read that thus far as saying that you reset both when either one or the other thing happens. And claim 6 uses the word and.
Yes, but you see, I think, in fairness, I think the point is, it is the point that my lord is putting to you. If when means immediately, then it does mean something more than is written in 6, because all 6 is doing is specifying that the resetting of these two things is to 0. But if when doesn't mean immediately, but means just whenever you feel like it after this has happened, then it's very difficult to see what difference there is from claim 6.
Well, my lord, as I say, this is not a point that we had previously considered, because everyone
But it comes from your new point about when and if.
Yeah.
And the other question I wanted to ask you about that is, again, involves looking at claim 1, because as my lord has just touched on, the word in claim 1 is if, whereas the word in claim 9 is when.
Yes.
Now, the fact that different words are used might be thought to be deliberate. I mean, look, I appreciate this risks getting into meticulous verbal analysis, and one mustn't do that. But nevertheless, there is a difference in language, and it might be said, well, that's intentional.
Well, my lord, it might be said that, save that, in the description, as I've already referred to, the patentee uses the words when and if completely interchangeably and loosely. And of course, I've already pointed out that the patentee also makes the point at paragraph 118 of saying that the fact that you've got additional steps or integers in between steps which comprise things well, that's something that falls within the claims, which also obviously suggests that when is to be given a wider reading. And I mean, you'll recall paragraph 58 as well tells you that steps may be performed in any arbitrary chronological order, and they may be performed simultaneously or in an altered, arbitrarily rearranged, decomposed, or completely reversed chronological order. So the patentee is telling you throughout the description, don't get too hung up on timing. This is not intended to be restrictive wording.
I'm still struggling with this. If taking a simple, at least from my point of view, simple-minded countery type effort thing, where you're counting PDUs transmitted, and you count them up in 1, 2, 3, 4. The method at 9 says you do the reset when the first predefined value, let's say that's the PDU counter rather than the
Yes.
data counter, is reached or exceeded. If when just means after, then you could perform the method appropriately claimed without without resetting the first counter once it's got to the number or it's one above the number you wanted, but letting it run on.
Well, my lord,
and just choose to do it whenever you want.
We're not seeking to put forward such a very broad construction. We're saying it means in consequence of, but it's not restricted to immediately. And so we do say it means in consequence of. So it's
you say it means in consequence of and at any time after. And why is my lord's question not equally pertinent on that basis?
Well, my lord, perhaps in consequence of is where I would plant my case, rather than at any time thereafter.
But
and so we say that
because you're resisting the construction that says it has to be more or less immediately. If it's not immediately, then it's at any time thereafter.
Well, my lord, I'm resisting a construction which says it has to be simultaneous, which is effectively what my learned friends and the judge's construction was, because the point there was on a counter, it's done simultaneously, and we say, reading this, the skilled person would not think that this was excluding a window-based mechanism, where it does it in consequence of, i.e. when the first predefined value is reached, it then does a reset. But it doesn't have to mean immediately.
But as soon as you say that, you're then into intervening event.
Yes, and we accept that there can be an intervening, or we say, it's part of our case, that there can be the intervening event of the receipt of the status.
It's precisely for this reason that you advance this construction,
yes,
because of the intervening events.
Indeed, and paragraph 118 tells you intervening events are absolutely fine.
Yeah.
And my lords, obviously, I'm sure I'm going to hear a lot about boilerplate language from my learned friend when I eventually let him stand up. But we say that it's still important that the patentee has put that kind of language in, and it demonstrates that they don't want the wording of the claims to be read narrowly. Now, I'm aware that I've now been standing up for longer than I intimated to my learned friend that I might be.
Well, you've had a lot
obviously,
of questions. You've had a lot of questions.
I was going to say, I'll obviously tell him that's nothing to do with me. But I did want to just conclude by saying that Optis complains that our approach amounts to picking apart the judgment on small points of detail. But we say these are not small points of detail. And in particular, in relation to counting, and we say, as the judge did, that the other points flow from this. this. The judge did not step back and construe the claim purposively. Given that window-based polling and counter-based polling achieves the same purpose, that is to prevent stalling, then there is no reason to exclude a windows-based mechanism from a reading of the claim. And having understood that purpose, the skilled person would not do that. And the language certainly doesn't tell the skilled person that's what the patentee intended, because the word counter-based could have been used, and nor does the context, because paragraphs 9 and 10 tell you specifically about the similarity and that the similarity is counting. My Lords, I'm very grateful for my Lord's patience. Can I just check that no one behind me or around me wants me to say anything else? And do my Lords have any more questions?
No. So we'll take a 5-minute break and then we'll hear from Mr. Meade.
From your undergrad. Yeah, I just want you're not nearly at the MA stage, are you? But you've only just graduated.
I should have graduated in 2019. Then
Oh my goodness.
changed tracks, and then the pandemic.
Okay, so when you change tracks, that's why I think that's confusing. I think you never and then you said and then do you have
Just 2 years. Which is fine.
yeah. Only the senior status thing.
Yeah. But I did it.
Yeah. Just done all the initial.
So yeah, that was nice. It's just really sad.
Yeah.
Court rise.
Yes.
May it please you, my lordships. Where I would like to start, if I may, is to address head-on an issue that has taken on increasing importance in the course of my learned friends' submissions, and indeed in the light of judicial questioning, which is the issue of whether or not a method, patent claims for methods, can be anticipated by another method that is said only to anticipate occasionally, some of the time rather than others. I just want to show where this comes in the learned friends' skeleton and how it's put, insofar as it is put, and see how the judge addresses it, and then address the two competing, as I understand it, analyses of it, of my learned friends, as between Lord Justice Birss and Lord Justice Arnold in terms of how these methods, how it should be analysed. But to start with, where this comes in my learned friends' skeleton, is on this core page 46, it's paragraphs 98 and 99. And then learned friend refers to the judge dealing with the law on anticipation, 148 onwards, 148, 150 are relevant to the issues on appeal. She refers to Meldau, which is fine. And then in 99, the judge did not deal here with the question of whether anticipation can occur when a method described in prior art anticipates some, but not all of the time. This is relevant to the anticipation of claims 6 and 9 for the reasons explained below. The correct position is that there can be anticipation in this situation. Now, this is the point my learned friend's been making. She has referred to digital on a number of occasions before you as a method where she says in the particular circumstances when it's being carried out, she says that's the interdigital method she's referring to, as if there was some other interdigital method. In truth, as the judge held, and as we'll see when we look at how he deals with this in his judgment, interdigital discloses one method, and one method only. It's a clear series of steps and things that are said to be done, and you perform that method, and there may be different results in terms of polling behaviour as a result of performing the method taught by interdigital, depending on other factors or the way in which you set certain matters that are not the subject of interdigital. But the point is not that there is a different interdigital method in the circumstances my learned friend refers to. It's that if you run the interdigital method in that particular set of circumstances, which are not particularly likely but can happen, then the polling behaviour looks like that which is in the patent. But it's not for the right reasons. It's not because you're performing the patented method. It's what I referred to at first instance that I suggested I shouldn't, as in the form of almost a cargo cult approach to it. It is appearing to do something that gives rise to certain results, but the mechanism underneath it, the method by which that polling behaviour is created, is not the same. It's not the method claimed by the patent. And this is exactly what the judge accepted and how he approached it. So let's look at what he says. If one turns to paragraph 150 of the judgment, so this is at core 114, core 114. Sorry, I've given myself a wrong. It's paragraph 148, 150, so core 113. Anticipation of law. What the judge dealt with when addressing the law anticipation, he sets out at 148 And then in 149, there was also no dispute that where a method claim is in issue, what must be disclosed by the prior art is all the method steps of the claim. It is not enough that a prior art method has the same result as the claim method. Navigation by the stars and by a compass might both result in heading due north, but they are different methods. Although Apple accepted this principle, and they did at trial, its arguments later lost sight of it. Now, where they lose sight of it, as we'll see as we turn on to the treatment of the judge's assessment of the particular circumstances that Mr. Bouet-Law put forward, that's Apple's expert, in the context of how interdigital might work, where they lost sight of it is that they said that if you run interdigital in particular circumstances, then the polling behaviour comes out in a particular way, and that's enough for anticipation. He rejected that. He rejected that on the basis that the method of interdigital is always the same. It's just the results that are different. And that's akin to his statement of the law here that was not quibbled. That navigation by the stars and by sat-nav may get you to the same spot, but it's a different method. So if we look at that, this is 2, 3, 3 in the judgment, which is at core 126. It's worth picking this up at 230 because this is addressing what Apple ran in terms of anticipation of claims 6 and 9. 230, Apple alleges anticipation of claims 6 and 9 by interdigital in a more complex way and on the basis that there is anticipation only in some circumstances. Apple says claims 6 and 9 are anticipated where, and the two that my learned friend relies on are little Roman 1, little Roman 2, all PDUs act, and no further PDUs set. And then the judge says it's not easy to understand as written, and then 232 says he's going to address some of the drawings that were put in cross-examination and some complicated cross-examination drawings that we put to Mr. Bouet-Law to show that that interdigital behave differently. He wasn't going to go into. But at 233, this is the key point. Before I get into showing examples, so these are the points that my learned friend has been taking you through and showing you in these particular circumstances. You get a reset or polling, as she puts it, reset, she puts it, in certain circumstances. He says, before going to showing the examples, I will say that I think they are ultimately beside the point, because the method of interdigital is always the same. What the examples show is that its output is, in certain circumstances, the same as, or very similar to a counting method. But that is not legally the question. Now, he comes back to this at 248, little Roman 2, which is the point my Lord Justice Arnold called out just this afternoon. So this is on call 132, but starting 131 is 248. When he's addressing, the judge is addressing claim 6 on the assumption that his construction is wrong. At little Roman 2, at the top of core 132, he says, I have held that it's not legitimate to look at the behaviour of the method in particular circumstances, and then one must look at the method itself. Pausing there, my lords, that is, in my submission, absolutely a fundamental precept of patent law and anticipation in relation to methods, and it is a precept that was accepted by Apple at trial because one must disclose all the steps of the method, and one must, in order to anticipate. So one compares a method with a method. But then says, if I wrong about that too, then Apple should focus on the no exceeding use cases. So the judge took the approach that what is
can I just ask a question?
My Lord, yes.
Because I understand the points you're making, but I think the argument that's put against you is that essentially what we're talking about here is manipulating data. Now, we're manipulating data for particular technical purposes, but in essence that's what the nature of the operation is. And so the argument is, well, you therefore have to see how the method operates when given a particular selection of data, it being found as a fact that that selection of data is not something that is unrealistic, albeit that it will only occur rarely.
My Lord, yes. But if in those particular circumstances, that particular data is that particular grist is fed to the mill, the method, and you turn the handle, and out pops something that matches what is claimed in the circumstance claim for that particular set of data. That doesn't mean you've got the same mill. It's a logical fallacy to look at it and say, because in certain circumstances I can get the same inputs. The test of whether you are carrying out the same method, in my submission, and this is the approach the judge took, is that whatever you do, whatever input you put into the method, the box that is the method, the same result comes out that is the patented, produced by the patented method. It's the flip side of whoever it was, Einstein, who said that the definition of madness is doing the same thing over and over again and hoping there'll be a different result. The method must give rise to the same result, otherwise it isn't the same method. And so what my learned friend did at trial, and what the judge rejected, and what she is doing now, is saying, if you curate a certain set of peculiar circumstances that the judge held were not impossible, and you operate the method into digital in those circumstances, then you get polling behavior that is the same in terms of polls going out, but not resets, but assume all this against me. You get polling behavior that is the same as the polling behavior of the patented method in all circumstances. But she's picking one particular set of circumstances. If you then operate a different method, you can come to the same result. But the point is it's a different method. And this is why it's different to the Celanese case. And I'll come on to this. I mean, in the Celanese case, what happened was, and it was a product by process claim, what happened was that there were particular, it was making acetic acid, and for particular concentrations and reaction circumstances that were being maintained, you could then, you maintain those, and as a result, you get acetic acid. Now, sometimes, accidentally, the defendant said, you would fall within the scope of the claim because your concentrations were within the scope of the claim. But that's not operating, and that's actually operating the method of the claim intermittently rather than operating, as in the present case, into digital, is a different method. If one did what happened in Celanese, if one ran the process in Celanese when it was infringing, then it would always infringe when one ran that process, because that's what happens with a method. Same thing, same result. What my learned friend is seeking to do is to use that as a jumping off point to say that if you run a different method, as we say into digital is, and it is different, it's window-based, it doesn't count in the way she strains the what is a count and so on and so forth to reach what she says is the conclusion. If you run into digital in certain circumstances, you get the same result as the claim. But that's, as the judge said, that's not relevant. What's relevant is the method the same? And the very fact, we take my learned friend's point about saying, well, she only relies on these particular circumstances. We say that dishes her on this case. That knocks her out, because if in other circumstances the method does not behave like the patented method, it demonstrates that it's a different method. If you do the same thing, you should get the same result. And the fact you don't get the same result when circumstances are slightly tweaked, when a PDUs are sent, when round-trip time is beyond a very short period, then you get a different outcome. And that indicates that it is a different method. And that's actually what the judge held at 233, when he said, I will say, I think that ultimately beside the point, because the method of interdigital is always the same. Now, it's a cheap shot, but I'm going to take it. The learned friend doesn't appeal that finding that interdigital method is always the same. And indeed, looking, and again, this is, I can meet my learned friend's arguments on the merits, I'm not doing it, but in terms of what the grounds of appeal say, the closest she comes to identifying this error is, I think, paragraph 12 of the grounds of appeal. And I only raise this because my learned friend said she was given permission to appeal on construction points by Mr. Justice Meade. This was certainly not front and centre in terms of that, and it's quite a meaty point of principle as it's being developed today. So this is the granted paper on tab 2, core 12 is page 12. So core 12 is where the paragraph 12 is. And so having gone through individual lack of novelty, claims 6 and 9, what's said is, since the claims are satisfied that the methods described are applied on some occasions and not every occasion, the claims are anticipated by interdigital. Now that, in my reading, and that's why I haven't addressed this in my skeleton, that is conclusory. These are the other errors that have gone on before, she says, at 10. The judge wrongly held that BTS minus VTA does not go abruptly to 0, and further erred in principle by applying his erroneous construction of when. And then 12, since the claims are satisfied, that didn't seem to me to be identifying an error of principle. Now, I'm not saying Malone can't run it, and she's argued it, and I'm going to meet it, but I do pray that in aid for why this isn't something I've dug in on in my skeleton argument. Now, just bearing this in mind, I'd like to take you to how this is, insofar as it is developed in my own friend's skeleton, because I'll deal with all this all in one point. It's instructive in my submission that there are points that conflate in the same paragraph different issues and shift from there being two separate methods being performed to the more complicated and thorny legal issue of performing what she says are the same methods but in different circumstances, and that leading to anticipation. So let me make that good where these submissions come in. At paragraph 101, so this is 446. So this is where, just to remind you, I've taken you to 99, which is the method described in the prior art, anticipates some but not all the time. 100, synthon, that's fine. Disclosure, I think that's an uncontroversial citation. 101, first sentence, this is on objection. There can be no doubt that there is infringement when an infringing method is only performed some but not all of the time. So there, on day 1, 2, and 3, I perform the method. On day 4, 5, and 6, I don't. Well, that's still infringement. That's what happened in Celanese. You know, every day bar Christmas, they weren't running it on Christmas acetic acid in that particular way. And that's the principle that Malone derives from Celanese. But then, the final sentence of that paragraph, it follows that where a method disclosed in prior art operates, so not a different method, operates in such a way that it falls within the scope of the patent some of the time, there is anticipation. My lord, that is, if one looks at that in the context of a method claim, and reads it as, so it follows that where a method disclosed in prior art operates in such a way that it falls within the scope of a method claim, some of the time there is anticipation. My lord, that is not, that doesn't flow from Celanese, and indeed, in my submission, it's a non sequitur, and it's actually logically incoherent, because a method must give rise, must be the same every time. And interdigital doesn't disclose two methods. It doesn't disclose an optional method, do this one way or another. It is a disclosure of one way of doing things. If it were truly an anticipation, it should anticipate all the time. And it's common ground that it doesn't. So, I mean, Lord, I could take you to Celanese and show you this, but take it from me, it's a product by process claim, and I think my old friend and I both summarised it fairly. And indeed, so just to summarise my position on this, there can be anticipation by disclosure of a method that is only performed intermittently. Okay, so if there were two options. But if the prior art method relied on is to be an anticipation, then it must perform all of the steps of the invention, and so should lead to the same result all the time when the same inputs are applied to it. And if you get a different result from the prior art when the same inputs are applied to it and to the claimed invention, there's a different result, then that is absolutely the touchstone of there not being the same method. Now, the reason why we say they're not the same method is when one looks at counting and comparison and so on and so forth, and I come to those on construction. But that's absolutely the fundamental principle here. The high point of a learned friend's case is to say that in certain circumstances, the interdigital method has the same result as the operation of the method claim. But that is not an anticipation, because it's not the same method that is being carried out. So those are my sort of, those are my overarching submissions on the intermittent method point. Unless you have any questions.
Well, only the same one I asked Ms. Lane. I take it your side isn't presently aware of any Board of Appeal case law on this question either.
My Lord, we're not. We will, as I'm sure Ms. Lane will be looking overnight, and whether good or bad for either of our positions, obviously we will be reporting back tomorrow.
Very good.
Mr. Shaw, can I just ask one question?
My Lord, yes.
It strikes me listening to you that the way you're pitching it is very general.
Well, yes.
And I wonder whether, in fact, there's a role for claim construction in this argument. Because not all definitions of methods necessarily define the result. I can imagine a case in which one might define a method and include, or maybe even entirely, but certainly include in it a definition of the result. But equally well, I could imagine a method that may not define what the result is. It may just tell you what the steps you're supposed to perform are.
My Lord.
So I just wonder whether it's pitched at the level of principle that you're putting at, whether it's a little bit more complicated than that, and it may depend a bit on claim construction. And the reason I'm raising that is that it would certainly help me if, when you get to some further point in your submissions, you relate what you've said is the principle to the specific claim constructions the specific claims that we're dealing with. It's not jumping off the page at me right now. I'll finish what the results are that you're talking about in this context. You don't have to tell me now, but you do have to tell me sometime.
My Lord, I shall. It's a helpful indication, and I will be, given this is a claim 6 and 9 point where that it really arises in, it's a key relevance to that. I was planning to address this area in the context of claims 6 and 9. It's just there had been enough discussion of it that I was concerned not to leave it without saying my two penneth now. But I will be, whether that's a good thing or a bad thing, I'll be back on this point later. So before I get into the sort of more detailed point-by-point approach to the issues my learned friend has raised and go through what we say extra needs to be taken in relation to the CGK and from the patent and on construction and so on. There's one other overarching submission that again arises from the way in which my learned friend has developed her case. She has perhaps, not unsurprisingly, focused on the issues of construction, which she relies on to say the judge got it wrong. And she says, okay, these are the three issues: the when in claim 1, the counting in claim 1, the reset in claim 6, the when in claim 9. Those success on those construction points, as within their individual claims, is necessary but not sufficient for my learned friend to succeed. But for this reason, if my learned friend persuades you that counting should be construed as she says counting should be, then as she puts forward in her skeleton argument, and we agree, I think it's paragraph 50, a fundamental integer of claim 1 is that the count must be then compared with a threshold, and there's a consequence of that comparison of each of the counts, that count, compare, request upon. So that's integer 1G is the comparison and the requesting of the poll. Now, my learned friend has said, well, there is counting that goes on, and she refers to two differences, VTS and VTS minus VTA, as amounting to a count, as within interdigital. But she hasn't explained beyond saying you can rearrange that equation in interdigital, and I'll come to it. She hasn't gone beyond that to say, well, what actually goes on? Is there any step-by-step performance disclosed within interdigital of the count, the comparison, the request of a poll? And the judge found that there wasn't. When the judge dealt with her rearrangement of the equation to give rise to what she says is the counter comparison, the judge says this is it's not disclosed as being derived in interdigital. So whether or not the skilled person might look at it and think you could rearrange it, it's not disclosed as such. And that's all in the context of, so we say, and I'll address this when I come to anticipation, that my learned friend, even if she's right on construction, we say she isn't, has not said why the judge is wrong on other findings he's made, and not explained why there is anticipation. It's not one of these cases where it all just flows if her point on construction is right. I'll make that good in the right moment. The second point is that the entirety of my learned friend's submissions have been focused on J within interdigital, and I'll come to explain the difference between J and K. J is a particular equation that is set out with great particularity. K is not. K, as the judge holds, is something that is, there would need to be more logic created in order to come through it. And so it doesn't follow, in my submission, as night follows day, that if my learned friend is right on counting and she somehow persuades you or explains that I'm wrong and that within J there is counting and comparison and the steps of the method, K is a different matter, and she doesn't explain that. What she says is she relies on the judge's logic. The judge says, I don't think it's, given my approach on counting, the same applies to J and K, and I don't need to go further. But that's not enough for my learned friend. She can't just then adopt the judge's saying, well, the same applies for J and K. She has to explain why the K can be rearranged in the way she says in order to give rise to anticipation. So it's not just a construction point. And so it's, although construction is very important in this case, in my submission, it is not enough, my learned friend, and it's certainly our position that even if my learned friend succeeds on construction, she hasn't, in the light of her submissions today, set out how all the other requirements, the step-by-step of the methods, are established in relation to both Claim 1 and Claim 9, so that she gets home even if she's right on construction. So with that, I'll turn, if I may, wishing to leave a cliffhanger. I'm really just flagging that up, and I'll deal with it when I come to anticipation. My next port of call is to go through the common general knowledge and flesh out some extra elements from the judgment that in my submission are important to understand the system. Then I propose to address you on the method that's described by interdigital, then turn to the patent, dealing first with the specification and the claims. And once I've done all of that, I'll then be in a position to say, well, where are we on anticipation? But that's the structure as I intend to deal with it, and I'm happy to deal with any questions as I go along. But first port of call, common general knowledge. Now, my learned friend has helpfully taken you through some relevant parts of the judge's description of common general knowledge. The first point that in my submission requires a little bit of revisiting or making sure that we understand is the concept of the sliding window at paragraphs 51 and 52 of the judgment, where this is at core 97. Now, 51, Malone addressed you on, which is the stop and wait protocol, and then 52, which is the subject matter of the dispute here and the patent, is the more sophisticated ARQ system using a sliding window. Malone addressed you and said each PDU is assigned a sequence number and allows the receiver to know which PDUs have been received and which are missing. This is a point she didn't amplify particularly. The importance about knowing whether PDUs are missing is dealt with in the next sentence, bottom of page 97 below judge. It also allows the status report to identify which PDUs are being acknowledged as received, act, and which are missing and being nacked. The sequence number also allows the receiver to reform the data stream into the correct order. There's a transmitter window of the number of PDUs which can be transmitted but not yet acknowledged. When the oldest PDU in the transmitter window is acknowledged, it's removed and the window moves or slides along. The reason why it's important to consider why I'm keen on NACT is that a status report will be sent by the handset if they receive sequence numbers, for example, and there's a gap. So there's something known as gap detection, which the judge addresses elsewhere, where, say, a handset receives sequence numbers 1, 2, and then nothing, and then 4 and 5, it will pipe up and say, I'm missing number 3, and will send a status report saying, can I have number 3? And so this goes on in the context of the normal operation of handset and system. And then, so if that happens, and if there is a request for a retransmission that comes from the handset, or indeed any retransmission, there can be a retransmission without any new sequence number being used. The retransmission goes out with the missing sequence number 3 is attached to it, and then that's slotted into place by the handset. And so this, in my submission, why it's important, it highlights the fact that sequence numbers are not, as Malone and friend says, a proxy or something to be viewed as would be viewed by the skilled person as the same as counting. They play a role that allows the system to function for reassembling these matters, the PDUs in the right order. They are labeling PDUs, they're not counting. Now, and indeed, this point is it's dealt with more clearly perhaps than I just have in a paragraph on letter and didn't take to, which is paragraph 58, which is the receiver decided to send a status report itself. This deals with gap detection. So that's your note at the bottom of page 98 of the core, paragraph 58, dealing with that matter. The next issue, which in my submission needs a certain amount of expansion, are the state variables that are at paragraph 67, page 100 of the core file. This is where the judge is identifying the state variables that are used. VTS, my friend has shown you, which is the base of the page 67 of Roman 1. This state variable contains the sequence number of the next AMD PDU to be transmitted the first time. It shall be updated after the aforementioned AMD PDU is transmitted. And then this is a bit Malone didn't take you to, but I'll just explain. Or after transmission of an MRW SUFI, which includes certain matters. So if there are other circumstances where the sequence number is updated, rather than just being ready for a new PDU, it can in fact be the case that if a large number of sequence numbers, PDUs, have gone missing in transmission, that the use of sequence numbers can be reset to an earlier number. And that truly is a reset, where it would be assigned a number, updated, not after the aforementioned ADM PDU is transmitted, but after transmission of this MRW SUFI.
What is an MRW SUFI?
It is a control message Malone Junior bundle was certainly before in the bundle that was appealed before the judge. And then VTA, if I can park that for the moment. VTA is the acknowledged state variable, and we see the same here. The state variable contains a sequence number followed by the sequence number of the last in sequence acknowledged AMD PDU. So that's the bottom end of the window. This forms the lower edge of the transmission window of acceptable acknowledgements. VTA shall be updated based on the receipt of a status PDU, including an ACK. So if the window slides forward, they're acknowledged. Or an MRW ACK SUFI. So again, this is another control message that I'm shipped. Then VT-PDU, this is the point that Malone didn't take you to, and it is useful. This is the state variable that is used when the poll every poll PDU, sorry, poll every poll PDU is configured. Now that, as we'll see when we look at the polling triggers, that is the counter. So the every poll PDU is the counter-based trigger that's in UMTS. And VT-PDU is the counter that counts for the counter-based trigger. Okay? It is the thing that is updated in this standard, incremented by 1 for each AMD PDU that is transmitted, including both new and retransmitted AMD PDUs. When it becomes equal to the value of poll PDU, a new poll shall be transmitted and the state variable shall be set to 0. The initial value of this variable is 0. So when, in the common general knowledge prior art, you have, in common general knowledge, you have the use of the counter-based polling trigger. What is used as the counter is not what the learned friend says is the counter, which is either VTS, or indeed this combination VTS minus VTH, he says you get from window-based polling. It is a separate state variable. Now that doesn't mean...
Where does the judge explain what you've just told us?
He said, so what will you get it from there? The state variable is equal to new poll. And he says...
Well, it doesn't leap out at me from that sub-paragraph, which is why I was asking the question. I'm wondering if he deals with it more fully elsewhere.
My lord, then let me take you back to where the polling triggers are in fact described, which makes it, puts it beyond dispute. This is at 61 on 499.
Yeah.
And it says the available triggers in UMTS, so these are the toolbox, and what my learner friend has shown you is 2 and 4, which are CGK. I think CGK as well. This is all in the CGK section, but little Roman 2, every poll PDU underline PDU, which is what we've just been looking at with VT PDU. This is a PDU counter. The system counts the number of PDUs sent. When that number reaches the value of the poll PDU, or poll is triggered. So reading that in conjunction with VT PDU, you learn that that is the state variable used when every poll, every poll PDU polling trigger is configured. It's hardly poetry, the names of the variables they use, but it's... So those are the polling triggers.
Is it one point of detail which was bugging me for a bit?
My lord, yes.
VTA, the acknowledged state variable, which is the bottom of the window, in effect. Is the upshot of all this that there are no NACT PDUs lower than this value?
Yes, it is the last in line. VTA is the last in line acknowledged PDU.
In the sequence, I see. That's what the significance of in sequence.
Last in sequence, so I used in line.
So you can be sure that you're never going to have to worry about PDUs lower than VTA.
Yes, once you have VTA, everything below that is free for further use. You can use those sequence numbers again. The buffer where those for retransmission of those PDUs is
But there might also be PDUs above VTA which have been acknowledged, but because something hasn't been acknowledged, has been negative or been nacked, I suppose, or just not acknowledged at all, they're still above A.
My lord, let me show you a picture that does that complete. Core 130 within the judgment. So this is one Mr. Bouet-Lord's models, when we're doing it, this is paragraph 241 at core 130. It starts off, if any PDUs are nacked in status reports, then the counter-based mechanism will still have reset to 0. So knacks don't mind the counter-based system, since it always does that. But the Windows-based mechanism will not see VTS minus VTA go to 0, because they will be separated by at least the knacked PDUs lodged in the window. This is your point, my lord, I think. And nor will the as-if, this is the point where the doesn't rely on anymore, reset happen, since as Mr. Bouet-Lord put it in paragraph 23 of his second report, and then these are the pictures. I'll allow you to read that. If you look at the two pictures, the red, the red PDU within those pictures has been knacked. The green ones have been hacked, and so the window is hung up on the red one in the left hand side, which is the window base. Thank you. I hope that helps. I'm not describe things more clearly on our occasions. While
sorry, just what do we see in the two pictures is one the counter and one the windows.
The right is the counter, VG PDU equals 2.
That's the counter.
And the left, J equals 100%, so the window is full.
Right.
A poll will be sent. Remember, I'll come on to this when we look at interdigital, but how interdigital works, how window-based works, is when you're above the threshold, it just keeps polling. It says, it's screaming for help to have its buffers flushed. It's saying, I'm above the threshold, and it sends a polling request. It sends another polling request, which is why what it doesn't do, if you've got a window-based poll, is if you don't reset, as it were, on my learned friends construction, you'll keep sending your every PDU that goes, there'll be another one, another call to send it, another poll goes. And indeed, one of the things that Mr. Bouet-Lord did in the pictures that you see, and the learned apprentice has shown you in the two preceding pages, it became clear in cross-examination, the judge records this, it wasn't done with any ill meaning, but what Mr. Bouet-Lord did was he imposed a form of poll prohibit timer, which I'm just going to come to in the common general knowledge, which was not the normal poll prohibit timer in the CGK. So what Mr. Bouet-Lord said was, in order to show you these polls not being sent every PDU when you're above the threshold, he said, I'm just going to cancel all of those. And he invented a poll prohibit timer that didn't send polls, it prohibited polls for a certain period. The common general knowledge poll prohibit timer, which I can show you now in the judgment, is at paragraph within the CGK. It's at the base of paragraph 65, which was a paragraph my learned friend took you to, but you didn't get as far as poll prohibit time. So this is on core 100, the factor a bit just above the send state variables. And this is a paragraph that starts off, the efficiency of the system involves a balance, stalling is very inefficient. And then if you look halfway down this, after the word superfluous polling, it says in the same paragraph as the UMTS standard, there is a reference to the poll prohibit function. Its purpose is to mitigate the problem of superfluous polling. The function works using a poll prohibit timer, which is a timer which starts counting when a poll is sent until the set period has expired. Any further polls are prohibited. If polls are triggered during the set period, which would have been sent but for the poll prohibit timer, these polls are delayed, with one poll being sent on the expiry of the poll prohibit timer. So it's all a bit complicated, but what happens is rather than, if within the period of the poll prohibit timer, so 10 units of time, there would have been any other polls requested for any reason at all, the system doesn't send those polls. It waits until the end of the timer, and then it sends one poll only, and that reduces superfluous polling. But, and this is some of the drawings that were put to Mr. Bouet-Lord in cross-examination about how interdigital system works and so on and so forth. if you have that kind of poll prohibit timer in place, and you're operating even under some of the assumptions my learned friends make in their special circumstances, if you have that kind of poll prohibit timer, the behavior of the counter-based system and of the window-based system diverges rapidly, and that's what the judge referred to in that paragraph 232, I think it was, where he says, Optis's diagrams made a very good job of showing how different window and counter mechanisms are in terms of polling and of tracking bytes and PDUs in circumstances of increasing but realistic complexity. I may not have to show you those, in that I think it's common ground that outside of the specific circumstances upon which my learned friend relies, the behaviour of interdigital and the behaviour of either window-based polling or indeed the patent are markedly different. And we say, part of my overarching submission, that means the methods are different. So, I was looking at the state variables. Within paragraph 61 of the judge's list of core 99, the learned friend took you to window-based, which is obviously the old part of interdigital. And I think she said that the J value was the threshold. I'm sure she just misspoke. The J isn't the threshold. That calculated sum is not the threshold. The threshold is a particular value of a state variable called poll window. And so it's only when J gets above that threshold, which will be a percentage, 50%, 80%, whatever, that's when it's done. But that's how it works. Now, there is an important part of a CTK because it deals with what is known about the differences and similarities, insofar as there are such, between window-based and counter-based polling triggers. And the judge deals with this in two places. So the first is at paragraph 64, where he addresses what the window-based approach, how it works, the distinction between the two. Now, this was in the agreed CTK section, and as I'll show you, there was another sentence. You can see where this all comes from. It's from actually Lord Justice Birss' original decision at the first instance. There's a sentence that was removed because it wasn't agreed, but the judge then deals with it later in the judgment. But at 64, the window-based approach, 4, keeps track of the percentage of the sequence number resource which has actually been used. So this is the outstanding point. It's those matters that have been used and therefore what's available, so outstanding matters. This is more complicated to implement, but more accurate than a PDU counter, 3. 3 is a typo, it should be 2, but it's a typo that comes through throughout this. And let me just show you where this comes from, because we had suggested in the attempt to agree with CTK that there was a further section, a further sentence that came in on this. And this is from within the authorities bundle. And I agree with my learned friend completely. This is a clean slate, and what previously we decided about this patent is not of relevance. But because there is the CGK was extracted from previous judgments, it's worth looking at. This is at tab 6 at page 168 of the bundle. Sorry, I sidelined these are not really authority, it's just the bits that were in there. But at 168, there is at paragraph 42, we can see where this derived from, this passage of the, and Mr. Justice acknowledged this and the help that he derived from this earlier decision. The window-based approach 4 keeps track of the amount of sequence number resource which is actually been used and therefore what's available. This is more complicated to implement but more accurate than PDU counter 3. That's where the typo first came from. A counter is simply an indication of the rate at which the resource was being used up. Now that was said to be CGK in that previous decision. We said it was CGK here, where the judge, it wasn't agreed, so it's not in that part of it, but the judge returned to this at paragraphs 112 and 113, which is the construction part that my learned friend has already taken to. So this is clause 109. And 112, sorry, clause 108. The judge, in discussing the disclosure of practices, a basic difference is that in the Windows-based approach, concerned with how much data is outstanding in PDUs or files. This means it's not merely driven by how much data has been sent, as in the case of accounting, but has to have regard to the current state of the transmit button, again in PDUs or bytes. That in turn depends on the status reports coming back, as well as how much data has been sent. And then at 113, these differences would also be known to the skilled addressee from the CGK. And then he goes on to refer to the point about being outstanding. So it was CGK that, as between window-based and counter-based, one is dealing with what's outstanding, one is dealing with the matters that he sets out in his treatment of the CGK. But counter-based is to do with, I think the early decision was referred to as the rate, but it's to do with the uses, what's been transmitted, what's gone out the door in terms of these matters. And that is a distinction between window-based and counter-based that was CGK and indeed is highlighted, as we see when we come to the patent itself. And so in my submission, without going too far forward to what I'll be saying on construction, it's a crucial part of the context of the judge's construction of the word counting, and indeed it's entirely appropriate that he took it into account when he came to his decision on counting. Now, my learned friend has, on a number of occasions in her skeleton, suggested that both window-based and counter-based, or windows and counting, both track use. And that is not so. Counting does not track the amount that is used. It counts what it is sent, just observes what's going out the door, like a rate. But it's actually just counting what's going. It's not taking any account of what remains for use within the sequence number window, or indeed the amount of unacknowledged PDUs that are outstanding. That is the heart of a window-based system. That is tracking occupancy, tracking availability, which is what window-based does. It's not what counters do. And that's why counters are less accurate, but window-based are more accurate, more complicated. And that's the trade-off that this invention deals with. Without, by the time you get to claim 9, what's clever about this invention, amongst many things, is that it uses the simplicity of counting and a congruence of resetting when either counter it passes its threshold, in order to avoid superfluous polling. And superfluous polling is what you get in window-based systems, because they keep polling when you're above the threshold. So, my lord, in my submission, it is absolutely fundamental that the skilled person would have approached the patent with that distinction between window-based and counter-based polling firmly in mind, and indeed they would have approached the patent bearing in mind that at that time they were viewed as alternatives to each other, which is what we get from that editor's note that my learned friend took you to within the judgment, where it had previously been decided in the draft standard that there would either be a window-based or a counter-based system. So the whole mindset of the skilled addressee, the context of which the patent was to be read, was there being a difference between window-based and counter-based, albeit that there is a similarity in that they both aim to prevent stalling, to reduce stalling. So that's what I wanted to say about the CGK, unless there's any further questions or any questions that you have on the point. The next thing I was going to turn to is into digital. I see it's 15:15. I hope I can continue for a little while. I'm in your hands.
how quickly can you deal with interdigital? If it's going to be 5
I can deal with interdigital in 5 or 10 minutes, I think. I'm in your hands. If I do it now, I don't have to do it tomorrow.
Go on. Get it done, and then we will rise.
Then I will deal with it as swiftly as practicable. Supplemental bundle, tab 2. You've seen this before. Sorry, page 22, sub 22. This is a modification. It's stated that it will be modified, but it is a modification of the known window-based polling trigger. And when it's set, just to explain how it works so we're all on the same page, J, which is that calculated figure, is compared with poll window, which is a set threshold. And when it's greater than poll window, it sends a poll and keeps sending a poll unless there's a prohibit until the value drops below the threshold. So that's how interdigital works. And what it's doing is tracking the proportion of the available sequence number window that is currently in use when you're dealing with J. So that's looking at how much of VTWS, which is the total window size that's available, is still available or has been used. And it does that by VTS plus 1, so 1 bigger than the next sequence number that's to be sent, and then taking away VTA. And the 4096 and the mod 4096 is just allowing it to loop. It's the modulo arithmetic. And what interdigital teaches, and it's in my submission, it is pretty clever, different to the patent, is to meet the issue that came in with LTE, or that was coming in with UMTS in particular, later configurations of different flexible RLC PDU sizes. So previously, I can't recall if I'm going to explain this, but previously in UMTS, PDUs were always the same size. And so when you send N PDUs, it doesn't matter, you know how much memory is being used. There is no tension between memory usage and sequence usage. Once you get flexible PDUs, they can vary wildly. And so if flexible PDU size is configured, the poll is also triggered for each AMD PDU, so it's every time the AMD PDU, when this is calculated, when K, the new value, is greater than or equal to a poll window. So it's saying let's compare to the same poll window threshold, 50%, 80%, whatever. Let's have a new metric that we will compare. And the new metric, K, involves the sum of the RLC PDU sizes from VTA to VTS. So it's the total of all of the outstanding data that has been sent and not acknowledged yet, or has been sent within the window, and then you divide that by the maximum transmit window size. Now, so it's not teaching counting and comparing either PDUs transmitted or bytes transmitted with different predetermined values, and then as a result of that comparison, requesting a poll. What it's teaching you to do is to, in the known window-based, you assess the percentage of your permitted number of sequence numbers that you've used, then you compare it with poll window. And here, with its new variation for K, you compare the percentage of permitted bytes that have been used with the same threshold poll window. So it's not two separate thresholds. It's not two. It's using existing mechanism in a different way to take into account memory. Now, the skilled person is told to calculate the sum of the values of PDU sizes for all the PDUs sent for the first time and not yet acknowledged. It's not being told to count the data that's transmitted, or even all the data that's been transmitted. It's counting, or it's calculating the current occupancy of the window whenever you need to carry out this test. Now, why I wanted to look at this now before we get on to the patent is there's a marked difference, and this ties in with my position on anticipation. There's a marked difference between the precise framing of J, which is an equation, just maths, my learned friend says, that has certain state variables. K is more of a descriptive do it. Just make a sum of these things. It's not an equation that can be easily rearranged to come to a particular value and say, because you've disclosed, my learned friend says, if you disclose with J an equation, then you've disclosed all rearrangements. We don't accept that. We say that can't possibly apply to K. Because as the judge observed, and this is the last reference before I'm done for the day, my lords, the judge observed at paragraph 219, this is called 124, when he's describing this, he says, this only comes into play when flexible PDU size is used. When it's used, the pole is also, i.e. in addition to the J trigger, triggered when the window occupancy as a percentage calculated by reference to bytes, total bytes in the window divided by maximum bytes allowed in the window, denoted by K, reaches or exceeds pole window, so the same threshold. K is not given as a formal, precise formula in the way J is. It is more descriptive. The skilled addressee would have to create some logic to track the sum of PDU sizes, but there's no suggestion that it could not be done. There's no suggestion it couldn't be done, but if one's talking about anticipation, my learned friend relies on a particular way of doing it for the purposes of her anticipation. She hasn't articulated any such case. If she were to do that, she'd have to say that was disclosed, and there simply isn't any such disclosure within K. My lords, unless you have any further questions, that's
Very good, thank you. We will pause there and resume at 10:30 tomorrow.
my lords. See us on YouTube.